Greetings, friends of liberty. I've just returned from a TARDIS mission investigating whether any female dimples in all of recorded history could match those extraordinary dimples of Miss Preity Zinta. And I could find none. Truly they remain singular in their beauty. But now again, let me assume my somewhat regional North American accent and focus on the topic at hand. The Civil Rights Act of 1964. Before we treat of the Civil Rights Act, the bureaucracies it created, and how they relate to the rise of political correctness, let's pause to examine the wider context of Jim Crow laws which necessitated a corrective response, briefly delineating, as I did with the tax treatment of educational philanthropy, what an ideal Civil Rights Act would have looked like. What we needed, a perfect 10 out of 10 Civil Rights Act. For those of you born in the 20th century, think Cindy Crawford, Kate Winslet, and yes, Preity Zinta. So this perfect Civil Rights Act, what would its assets have looked like? Number one, easy to understand. Restore to blacks all civil rights, such as of voting, jury selection, interracial marriage rights, and enlistment in the unsegregated armed forces. Given the great importance of voting rights in protecting other rights, this simple rule, if enforced, would likely have solved many Southern problems. Number two, somewhat harder to understand, abolish all big government institutions that, as they do to this day, violate the natural civil liberties of black and white parents and children, such as public education, which also violates, in fact, the separation of church and state by forcing private religious parents to support secular state schools with their tax dollars. Or expressed in cost-benefit terms, since big government institutions like public schools intrinsically violate rights, and also, as Sol pointed out in the last video, by nature are more racist, like postbellum Southern public schools for almost a century, and like more and more K-12 schools in 2022, teaching white children to hate themselves, eliminate all such comparatively racist governmental institutions. Three, hard to understand. Abolish all laws restricting the freedoms of private institutions to do whatever they want, which restrictions were precisely what Jim Crow laws embodied, i.e., they legally forbade integrated streetcars, railroads, hotels, bathrooms, restaurants, and so on. The famed court case Plessy v. Ferguson, for example, was brought precisely because Louisiana used state law to enforce railroad segregation. This alone would have been highly effective over time in allowing and incentivizing fair treatment, which actually happened in many cases by private companies before Jim Crow laws had been strictly enforced, since these Jim Crow laws, for example, in requiring segregated streetcars, often raised costs for the company and aggravated the ridership. In sum, an ideal Civil Rights Act models the ideal societal principles governing romantic relationships. So any law which prevents relationships between the races, such as those preventing interracial marriages and mixing in public accommodations, should be abolished, but any affirmative action law which forces relationships between the races or sexes, such as laws forcibly inserting blacks and women into institutions, should be disallowed. This should have been the guiding principle of contemplated civil rights legislation, but it wasn't. What we got instead, a subpar 4 out of 10 Civil Rights Act. Think Lena Dunham, Valerie Solanas, and Diane Downs. Explicitly denied by its champions in Congress as it was being crafted to ever mandate or legislate the introduction of racial quotas, no quota system shall be set up, the Civil Rights Act of '64 was nonetheless, as its detractors had argued, interpreted by the courts and used by affirmative action bureaucracies subsequently created, such as the Equal Employment Opportunity Commission, the Office of Federal Contact Compliance Programs, and the Office of Civil Rights in precisely this fashion. Added to this sweeping morals legislation was President Johnson's 1970 Executive Order 11246, affecting federal contracts, and Title IX of 1972, which in effect mandated sexual and gender discrimination against men in colleges and universities. The total effect of this legislative and bureaucratic conglomeration vastly expanding the potential group of alleged victims. Now, by what legal rationale and method do these civil rights laws and the subsequent judicial decisions supporting them impose their harm and injustice on educational, governmental, and business institutions? Primarily in two ways. Firstly, by imagining that they could divine discrimination via racial percentages and impose or threaten quotas as a remedy, and secondly, with sexual harassment law, by the subjective, injured feelings of women who felt or imagined, in some cases correctly, and others incorrectly, not only that they had been mistreated morally, but that their natural rights had thereby been violated. A bit later, the Civil Rights Act of 1991 cemented in place the use of disparate impact test and the use of the business necessity clause as a justification for its racist treatment. Let's examine these judicial rationales, that of disparate impact and business necessity, briefly. So, disparate impact. Despite Supreme Court Justice Warren Burger's attempt to disparage company testing by writing for the majority in Griggs v. Duke Power that the facts of this case demonstrate the inadequacy of broad and general testing devices, the actual reality for anyone who learned to read in grammar school was that Congress, again, never outlawed tests, which by one estimate would result in national productivity being increased by over 1% simply by their greater use. Imagine that. If widespread testing were allowed, national GDP could be increased by over 1%. And why doesn't the EEOC allow it? Because they have no idea or don't care that they're actually hurting minorities by outlawing tests, and they falsely imagine most employers are racist. Additionally, as economist Richard Vedder noted, the result of this Griggs decision, one of the landmark early cases enforcing a ban on testing, was to actually reinforce the quasi-monopoly power of colleges and universities to force people into them. Why? Since now other effective ways of testing for ability and personnel fit for a company or job, which would allow those not in college to prove their aptitude and suitability without paying the increasingly astronomical sums for getting a diploma, were now disallowed. And so, post-Griggs, from 1977 to 2005, the income differential between those with and those without a diploma has risen from about 45% to close to 90%. And since minorities are poorer, making it harder for them to afford college and a diploma, and now in addition by this decision making it harder to prove their value by doing well on a test, the reality is that the actual impact created by Griggs has been to harm minorities more than whites. Yes, a grim and ironic result, but merely another of the unintended negative consequences of the Civil Rights Act. Next, the excuse of business necessity. This criterion, again, a pure inventive deception by Burger and Company, and not found in the Act, prevented companies from using the above-mentioned intelligence, aptitude, and other tests to fine-tune company fit, asserting, contrary to all evidence, that the qualities measured by tests were not necessary somehow for the business in evaluating a potential employee. This, of course, is absurd. It would be analogous to saying that, when evaluating a woman's beauty, it's not necessary to judge the beauty of her skin, hair, smile, gait, voice, and dimples, but only her figure and face. Obviously, with both potential employees and women in beauty pageants, all relevant qualities should be included. The racist and sexist quotas and standards promulgated by this legislation and their supporting judicial decisions have been by now so thoroughly injected into the administrative DNA of American institutions and have bled into general culture that, for example, the California Highway Patrol, I kid you not, actually has traveled south of the border to find enough Hispanics for their force. MIT cheats so much with affirmative action that by their normal standards they would only let in 1/4 the number of blacks that they do, with the result that many then leave. On the other side of the river in Boston, where K-12 public school teachers are usually fired by seniority, teachers are now fired simply because they're white. Back across Longfellow Bridge, Harvard, desperate for qualified blacks, both rich and poor, is searching not only through every Middlesex village and farm, but also the entire length and breadth of the country and provides virtually carte blanche scholarships to anyone studying while black. In Alabama, black skin privilege can be so great that being fired after flunking 5 tests of competency is nonetheless judged as discriminatory and worthy of back pay and reinstatement. And finally, on television, where Hollywood is overwhelmingly liberal, whitey is naturally cast to commit 9 out of every 10 murders. These are the predictable results that occur when you create legislation that only protects one race. Is any institution exempt from these quotas and the costs and paperwork they entail? Yes. The Midnight Black Nation of Islam, receiving millions in federal contracts with its black skin privilege. Do you really imagine that those Equal Employment Opportunity Commission grads from Harvard, Yale, and Princeton have the testicular fortitude to confront the likes of the Nation of Islam? Any more that they dare apply employment law to sports leagues like the NFL or the NBA? Again, the act from the very beginning was really meant to apply to one race and one sex only, which one-sidedness Mary F. Berry of the Civil Rights Commission forthrightly defended by asserting civil rights laws were not passed to give civil rights to all Americans. So what was the general result then of the Civil Rights Act in addressing racism and sexism? To paraphrase legal scholar Richard Epstein, who wrote Forbidden Grounds, the case against employment discrimination laws, it is a complicated body of law that has resulted in the ability to discriminate against Caucasians and males, and especially Caucasian males, and made it easy to indict companies that show no evidence of prejudice or discrimination by misinterpretation and misrepresentation of the statistical evidence. Obviously, all society loses as a result, by whites and Asians never being hired or as students getting in, and by blacks and Hispanics who can make the grade being regarded as incompetent, and those who wouldn't have made the grade flunking out and becoming bitter at having been exploited by liberals anxious to preen in their social justice mirror. Those brilliant, hardworking Vietnamese, Indian, Chinese, Jewish, and Korean kids that might find a cure for Alzheimer's or skin cancer? Gone by the judgment of members of Congress, Justice Berger and his band of judicial compadres, and the racist liberals in Cambridge, Massachusetts, and in their place a BIPOC whose likely chance of doing that, given his average STEM performance, is immeasurably smaller presently. Now, if one happens to object to this destruction of medical brilliance and productivity and the societal harms for everyone that result, you'll be shunned, like the researcher and Dr. Bernard Davis in the Harvard Quad when he pointed out in an article in the New England Journal of Medicine that blacks at Harvard Medical were being admitted on a charitable basis, or like noted scholar Stefan Thernstrom at that same venerable institution when, among other sins of sincerity, he had the temerity to remark to his students, whose school motto is veritas, the truth that welfare dependency is more characteristic of the black community. Of course, it must be admitted that Davis and Thernstrom are white. If you're black with black skin privilege, as the brilliant John McWhorter has, then you can get away with saying the truth, as John has done on numerous occasions in calling out the destructiveness of affirmative action. One final point on the Civil Rights Act. What happens in those extremely rare cases when American colleges don't engage in racial discrimination? What happens is related by Steve Ferron. Again, I paraphrase. Our 1960 class at Columbia was chosen almost entirely by SAT scores, with the result that it won more fellowships than any other collegiate institution, even though it had less than 700 students. But perhaps not a surprising result, since it was 9/10 Jewish. And what happened to Dean Dudley, who was responsible for the decision to admit students purely on the basis of merit? He was sacked. Now let's go to Title VII, Sexual Harassment. Instrumental in the wholesale transformation of gender law occasioned by Title VII and IX, which again weaponized morals legislation into powerful federal agencies of persecution, was a lineup of scholars, activists, susceptible judges, and agency directors educated for the most part in select, nonprofit, private institutions. Batting leadoff was Catherine, I call it rape whenever a woman has sex and feels violated, McKinnon, from Harvard, Yale, and Michigan, notable for developing the strain of legal scholarship arguing that exhibiting pinups at work and commenting on them can be sexual discrimination. Along with her fellow archfemme from Bennington, Andrea, nothing is less an instrument of ecstasy and more an instrument of oppression than the penis, Dworkin, McKinnon, true to her animus against free speech and property rights, also attempted to craft legislation in Indianapolis and Minneapolis to outlaw pornography. However, having previously defined pornography as the sexually explicit subordination of women, they conveniently forgot the existence of dominatrices in pornography and in regular films, such as The Revenge of the Pink Panther, Maîtresse, and Venus in Furs. Title VII is a pure violation of the natural right to free speech, no less than if a policeman were allowed to enter a home, proceed to its kitchen, and dictate to the spouses seated there the content of their conversation. As such, it's a regression of civilization, and constitutionally likely a violation of the First Amendment, to which modern Supreme Court justices, acquiescing to its politically correct pleading, have acceded. As a result, McKinnon, her cohort of affiliated feminist lawyers, and conformist judges have unleashed on American society a violence of the state against all institutions and a persecution of males throughout commercial, governmental, and academic life, with attendant damage to both economic productivity and human happiness. What then do men tell of their experience when they work in an office environment whose speech is now controlled by the misandrist feminists who created Title VII? It is to be subject to the ever-present threat that every innocuous remark will be interpreted incorrectly, and thus the need to not joke about much of anything or to forego attempting to create a lighthearted esprit de corps that makes work a joy instead of a drudgery, while at the same time tolerating the verbal abuse of women who are allowed to make all the pejorative jokes they like, demeaning men, since they still retain their civil liberty to free speech under Title VII. In other words, it is to acquiesce at the threat of losing your job in tolerating and working in a hostile work environment, not only for men, but also for the women who want them to be happy. In sum, This is the social justice of Title VII in action, with its unavoidable violation of the Equal Protection Clause of the Constitution. We come next to the era of President Clinton, who appointed heavy-hitting feminist Norma Cantu from Harvard to be head of the Office of Civil Rights from 1993 to 2001. Cantu specialized in using the now 700-strong office and coercive extra-legal means to push the limits explicitly authorized by the Civil Rights Act. Typical examples were firstly her advice to colleges and universities after the Supremes in 1996 outlawed considerations of race as a factor in college admissions to continue nonetheless being racist. And secondly, her implying that Title IX regulations meant that the number of female sports teams should be maintained at the sex ratio of any given college. But more on this later. Next up in the Chronicles of Wokeness was the election of President Obama, who heralded a further descent into the racism of identity politics while cloaking his intolerance and divisiveness in the usual liberal rhetoric of racial tolerance and justice. Obama appointed the junior quota queens Ruslan Ali from American University and Northwestern, 2009 to 2012, and Catherine Lamont from Amherst and Yale, 2013-17, as heads of the Office of Civil Rights. So Ruslan Ali's 2011 Dear Colleague letter, and later Kathleen Lamont's guidance, intimidated colleges into creating kangaroo courts, such creations of course entirely unmentioned in the Civil Rights Act, to try young male students for the usually fictitious charge of rape or assault, without, among other things, allowing the accused counsel, to question the accuser, or to bring much evidence to the inquiry, thereby deliberately trying to replicate the template that was the moral farce of the Duke lacrosse case across the campus of over 7,000 American colleges. When Lamont was asked before Congress, who gave you the authority to rewrite Title IX through guidance documents, she answered, well, with gratitude, you did when I was confirmed. The corresponding highly exaggerated number of alleged college rapes and sexual assaults reported as of 2017 was over 20,000. As a result of these alleged violations, processed through these kangaroo courts, thousands of men's lives have been damaged by these unjust accusations and by these show trials. A typical professor who was falsely charged remarked, and I paraphrase again, I don't enjoy teaching anymore and stay away from engagement with females unless I know them well. And I always make sure to have another person in my office when talking with women, or I just avoid private meetings altogether. The result of my unjust persecution was that, as students, women now get a very different treatment from me than men do. And to imagine, in their scapegoating and carping, the modern academy lectures us all on the omnipresence of male privilege. Finally, Title IX and college athletics. Just as the apparatchiks directing the Soviet 5-year plans thought they could centrally plan an economy, so too the coercive feminists listed above thought to control the athletic gender growth and balance of sports teams in colleges. The rationale for and origin of Title IX's anti-male discrimination in athletics was the doctrinaire idea, disproven in thousands of studies over the last half-century, that all differences between the sexes were mere social constructs, and thus, if in a college composed equally of males and females, there are fewer women's teams, or there is less funding for women's teams, then we know these colleges are sexist. The mathematics of this 50-50 logic meant that, the actual gender reality being that men, as in larger society, like playing sports more, watching male sports more, and thus that their sports teams earn more or garner more alumni funding, the naturally expressed disparity in the number of teams and funding reflected in these actual choices of collegiate men and women. just like the actual choices of consumers in the Soviet economy, and that those choices would be ignored. As the EEOC wrote in another context, respecting the preferences of coworkers, the employer, and clients or customers is not allowed. Instead, the coercive power of the Department of Education and Office of Civil Rights would now cram their own misandrist ideological preferences down the throats of everyone. And so they did. Unleashed in a typically Democratic administration by Clinton, as Obama later did with the destructive Office of Civil Rights heads Ali and Lehman, the aforementioned Norma Cantu began by ratcheting up the number of investigated cases of alleged gender imbalance in sports teams. Her constant alleged violations, uniformly backed by court enforcement when disputed, leaving colleges little choice when they lost but to acquiesce. And thus, over the next decades, male teams in cross-country running, tennis, swimming, gymnastics, wrestling, and baseball were eliminated by the hundreds, and relatively unpopular women's teams, watched usually only by their parents, team members on the bench, and 12 spectators in the stands in sports like synchronized swimming, water polo, horseback riding, and squash were added. In this way, Title VII, while being unnecessary anyway, since colleges were already transitioning before its passage to giving women more access to sports, significantly damaged collegiate sports overall. And of course, men and the women who love them. And so here, dear listeners, I end this section on the Civil Rights Act and its various terrible titles. In my next and final video, I shall conclude this series detailing the cause of political correctness in the U.S. Until then, I wish you well and remain the Scarlet Pimpernel.